Please, Lordship. Lordship, I beg to mention this item number 4, Lordship, on the main list. Lordship, I've taken the consent from the other side.
From the main list?
Yes, for main list. Item number 4. Lordship, I'm praying for 2 weeks' time, Lordship.
No objection, Your Lord.
On pre-made by the petitioner, not objected to by respondents, list this matter after 2 weeks.
Apply, Your
Duly
Lord.
obliged.
May it please, Your Lordship, I beg to make a mention of item number 2 and 3, Your Lordship.
You are for?
I'm for respondent, Your Lordship.
This is with regards to that ACP and MSP, my lord. They have filed a additional affidavit, my lord. So let it come after 2 weeks, my lord.
On pre-made by the respondent, Union of India, not objected to by the petitioner. That is adjourned. This is same after 2 weeks.
Hello.
This is 3 and 2, 2 and 3.
2 and 3, Your Lordship. Similar prayer for item number 8 as well, Your Lordship. For the petitioner, Your Lordship.
Yes.
There's no objection from my side.
Pre-made by the petitioner, not objected to by respondent. List this matter after 3 weeks.
Much obliged, Lordship.
Supplementary cost list, item number 1.
please, Lordship. Lordship, in this matter, the case diary was called. And Lordship, I have received the copy of the case diary. Lordship, there is a medical report. And as per this medical report, Lordship, the victim boy, he was stabbed with a knife on different part of the body. Lordship. I'll just place this case diary, copy of the case diary.
Yes, Mr. Hassan. what do you
Yes,
have
my
to
lord.
say?
My lord, at Annexure 2 in my bail petition, my lord, page 12, my lord, the order of the bail application rejected in the lower court, my lord, in the district court, my lord. My lord, may I read, my lord? The second paragraph, third line, my lord. The learned, page 12. The learned additional PP so-and-so is present and submits that she has no objection if pre-arrest bail is granted, as injuries are simple injuries. That though the IO has given objection, she has not objecting as the injuries are simple injuries, and that the incident happened due to a scuffle between two parties and no sharp weapon was recovered, Your Honor. And moreover, Your Lordship, the victim has recovered, my lord. And petitioner herein is a student of class 12, my lord. He is going to write his exam from 28th February, my lord. It's a final exam, my lord. So on this ground, my lord, I humbly pray, my lord, bail may be granted, my lord.
Lordship, earlier also the bail application, it was rejected, but that order is not enclosed in his bail application. It's in the case diary, Lordship. Lordship, I will be allowed to place this case diary.
This is
Lordship.
the second bail
Lordship,
application
I'll
was
just point out
rejected.
the observation of the court in the earlier bail application, earlier order. It's at page 14. Lordship. Page 14.
Yes.
I'll read from the beginning, Lordship. I'll read this order, Lordship.
Yes.
Shri so and so, there are three petitioners, Lordship, in this bail application. Have filed application under section 438 CRPC, respectively, apprehending arrest in connection with Rajaplia's case number 14 in bracket 10 2023 under section 324 307 and 34 IPC, which have been moved by the learned counsel Srimati so and so. The petitioners are praying before this court for grant of pre-arrest bail, contending that they are not involved in the instant case. Learned additional PP Srimati so is present. CD and report as called for has been submitted. Heard both contending parties. Prosecution has objected to the grant of pre-arrest bail, as the IO has shown strong objection and there is prima facie case against petitioners, that the petitioners are not cooperating with the investigation and are misleading the investigating agency. Defense counsel submits that no sharp weapon was recovered and no knife was ever used by the accused person as alleged. The petitioners have cooperated with the investigation and have appeared before the IO and have not absconded. Heard the submission of both parties and perused the case diary as well as the record. On careful perusal of the case diary, this court has reason to believe that there is prima facie case against the petitioner's accused person, since the victim has stated that one of the petitioner, Shirajul Islam, held him along with the other accused person, while Nur Alam and Arshid Alam had assaulted and stabbed at the victim, and there were other witnesses to the incident who had come to the rescue of the victim. The medical report showed that the injury was inflicted by a sharp weapon. There is reason to believe that it is a case of attempted murder, as the victim would have been killed had the eyewitnesses not intervened and helped the victim. All the petitioners are party to the commission of the offence. The case diary reflects that the victim is still under treatment. Nobody should be allowed to break the law as he or she wishes, and thereafter take for granted that he or she will be granted bail as per their wishes. If this is allowed, then there will be a total breakdown of law and order, and the law-abiding citizen in society will lose faith in the justice delivery system. The case is very serious in nature, and court cannot take a lenient view and turn a blind eye. Law has to follow its own course, and every legal act has legal consequences. As such, in view of the reasons stated above, the pre-arrest bail cannot be considered and hence rejected. Order dated 06/11/2023 granting pre-arrest bail to the petitioner stands vacated. So this is the observation of the court below. And there are 2 eyewitnesses, Lordship, and their statement have been recorded under section 164, under section 164 CRPC. And the medical report is at page 1, Lordship, page 1. He was taken for examination immediately on the same date after the incident. Page 1 on the top, Lordship, by what weapon inflicted? Sharp weapon.
Where is it?
On the top, Lordship.
Page 1.
1, 2, 3, 4, page 1 or page 2, Lordship, page 2, sorry, page 2. On the top, 1, 2, 3, 4, 5, the fifth column, on the top, sharp weapon. So it was with a knife. He was attacked with a knife on different part of the body. So the observation of the court below is that it is a case of attempted murder.
No, but the nature of injury is
Nature of injuries are simple on different parts of the body.
Nature of
Nature of
injuries are very simple, my lord.
Simple, yes.
My
That
lord.
is not disputed. It's as per the
And my
report
lord-
is simple.
just
Simple.
And my lord,
if it's simple injury, you see,
Yes, my
it may not be 326, it may be 323.
my lord, yes, my lord.
In course of an investigation, of course.
But they have denied it.
It may also turn serious. We don't know.
And 324 is bailable, my lord.
But they have denied it, Lordship.
Only because of
they used a
307.
sharp weapon, a knife, to attack the victim.
He only held him, my lord, because
The intention
during
is
the
there to
both the
harm him.
parties,
Just a moment.
Let's
I'm-
just,
yes, ma'am.
the intention is there to harm the victim boy, Lordship, with a knife. They came prepared with a knife.
Oh, that of course.
Lordship, just my submission. Lordship, from the statement under section 164 of the witnesses also is there.
Any eyewitness who have seen that it is this particular prisoner who has
Yes, Lordship, 2 eyewitnesses there.
who has stabbed the
Yes,
victim.
yes, 2 eyewitnesses are there, Lordship. Page 17 and 16. Their statement have been recorded under section 164. Page 16 and page 17. 16 and 17. Lordship.
Who is the
I have
petitioner again?
paginated the case diary. Page 16, Lordship. Page 16 is the one witness, and page 17 also another witness.
Just a moment.
May I read it, Lordship?
Yes.
May I read it?
It's not necessary for you to read.
Lordship.
No, he is not the one who had actually stabbed the victim. The person who has actually stabbed the victim, according to the eyewitnesses, is this Ishaq.
yes, yes, my lord.
Shirajul and the other one, they were
They were-
holding him.
they were
They were
holding
holding him. Grabbing, they were holding him.
So they were not exactly you see, prima facie, they are not exactly the one who had committed the act of assault.
And Lordship, they are not revealing this weapon also, Lordship.
Oh, that was.
They are hiding, they are not revealing it. The IOs,
Are they arrested?
no,
No, my lord, not yet. They are apprehending their arrest, my lord.
they were on interim bail, and later on the court vacated the interim bail.
My lord,
Now only one of them has approached this court.
my lord, yes.
So I leave it to your Lordship. That is all, Lordship.
My lord, my first humble submission is, my lord, he's a student, my lord, of class 12. His exam will start from 20th February, his practical exam. 20th February, my lord, this month. And his theory exam will start from 1st of March, my lord. He's a student. And he has no criminal antecedent in my lord. He's just 19 years of age, my lord. And he is admitted, my lord, he was present during the spot while the incident was happened. He just he makes an attempt to rescue the, he hauled him, my lord.
That
That is the only, my lord. He
As per the
admitted, my
case,
lord.
that is a matter of
Yes, my lord.
investigation.
Matter
and
of
evidence.
investigation. My lord is correct.
as per this case,
Eyewitness says that you are involved.
as
My
per the
lord,
records, Lordship, there were 5 of them, 5 accused persons. So
There are 5,
this
my lord.
victim boy, he was going to his relative's place, and that time they attacked him. 5 of them,
Both
including
the parties are
including
a
the
family
victim.
member. They are related to each other. And during the last order 4th January, they have submitted before the court also. There is a settlement between both the parties.
That's a different thing.
I'm not going to that, my lord. I'm going to only,
Anyway,
my lord, I'll submit to judgment, my lord. The
it
honorable.
doesn't matter.
Yes, my lord.
Mr. S.K. Hassan, Direct Counsel for the petitioner. Was interim bail given to you?
Yes, my lord.
Have you appeared before the IO?
Yes, my lord. He appeared, my lord.
When?
He appeared, my lord, on on
Is there anything in the CD, Mr.?
CD, there's nothing here in this CD. Lordship.
It should be.
I'll just get the instruction from the IO, Lordship. Right now, let it be taken up.
Just
after
yes,
some time.
just to
on the
know
last
whether-
Friday he appeared, my lord. Last Friday, as per my instruction, my lord. He was called by the IO. He went to the police station Rajabala and appeared. His statement was recorded, my lord.
So what do we do? Should we take his statement or should you confirm?
I'll just call up the IO. I'll confirm from the IO. Let it come after the
End of the board.
at the end of the day.
My lord. Yes, my lord.
Obliged.
Obliged.
Item number 5.
May I please, Your Lordship? Lordship, we need some more time to file the affidavit to bring on record the age proof of the petitioner, Your Lordship.
You are for?
For the petitioner, Your Lordship.
Submitting for respondent? What is required?
Age proof, Your Lordship, affidavit to bring on record.
Age proof.
Yes, Your Lordship.
Is there any order to that effect? Ms. Leonard, counsel for the petitioner, has submitted that the affidavit to bring on record the age proof of the petitioner could not be filed today, and some more time is prayed for the same to be filed.
6. Number 5. Sorry, Your Lordship.
You are there in this case?
This is Simo Bhattacharjee is on leave. Yes, Bhattacharjee.
On permit, the same is allowed. Let the said affidavit be filed within the next date fix. This is matter up to 3 weeks.
Highly obliged.
Item number 6.
May it please Your Lordship, this matter pertains to Checkgate matter, Your Lordship, whereby a similar matter is pending before the division bench, Your Lordship.
Division bench.
Yes, Your Lordship. So I humbly pray, Your Lordship, that this matter may be adjourned and may be listed after 3 weeks, Your Lordship.
Ms. K. Gurung, learned counsel, appearing for the petitioner.
For the petition, Your Lordship.
Petitioner who has submitted that a similar matter involved in this case is also being taken up by the division bench of this court. The decision thereof which would have a bearing on the merits or issues raised before this court in this petition. As such, it is prayed that this matter may be adjourned for the time being. On prayer made, you are appearing.
State respondent, Your Lordship.
Leonard G. appearing for the state respondent has no objection to the prayer made. On consideration of the submission made, the matter is adjourned. List the same after 4 weeks.
Right, Your Lordship.
Lordship.
Second call from supplementary course list, item number 3.
He went to appear on the 2nd of Feb, Lordship, after the interim order.
But you have not annexed the statement.
My lord, yes.
Statement, no, it's not annexed.
He informed me while police called him, and he submitted the order passed by this honorable court 30 January, my lord, the interim order.
Mr. S.K. Hassan, the counsel for the petitioner, who has submitted that an FIR was lodged before the Rajawala police station on 21/10/2023, wherein it was alleged that the son of the informant, on the way to his relative's residence at Kandargaon village, was attacked by 5 persons. Resulting in bodily injuries to his said son. The FIR was accordingly registered and as Rajawala PS case number 14/10/2023 under section 324/307/34 IPC. The petitioner herein had a petitioner herein has admitted that the said incident happened in his presence. However, the fact is that he had made an attempt to rescue the victim, but to his surprise, he was also implicated in the case, and the police are on the lookout for his arrest, thus apprehending arrest. This application is now filed before this court under section 438 CRPC with a prayer for grant of pre-arrest bail. The Learned Counsel, next, the Learned Counsel has further submitted that the petitioner is a student of class 12 studying at Bari Higher Secondary School, West Garo Hills, and is due to appear for his final examination, which will commence from
20th February, my lord.
2024. It is also further submitted that there is no criminal antecedent as far as the petitioner is concerned, and being a young man of 19 years old, if arrested, his reputation and future would be in jeopardy, not to speak of his mental state as far as preparation for the upcoming examination is concerned. It is therefore prayed that this petition be allowed, and the again, it is submitted that this court, by order dated
31, my lord. 30 January.
31/2024 had allowed the petitioner to go on interim bail with a direction for him to cooperate with the investigating officer, and accordingly the petitioner had met the IO on which date?
My lord, on second, my lord.
On
2nd February.
2/2/2024, and his statement was accordingly recorded. The next it is therefore prayed that this petition may be allowed, and the petitioner may be granted pre-arrest bail with any condition to be imposed as deemed fit by this court. Mr. H. Karmi, Learned Additional PP, on the other hand, appearing for the state respondent, on the other hand, has strongly opposed the prayer made and has submitted that the petitioner has previously filed a similar bail application before the Sessions Court, which was rejected. The reason being that his involvement in the assault case has been established prima facie on the account of eyewitnesses, two of them having given their statement before the police. The additional PP has also submitted that the victim was assaulted by a sharp weapon, as is evident from the medical report, and accordingly a case of attempted to murder under section 307 is made out. Considering the gravity and seriousness of the offence, it is submitted that this petition may not be allowed at this stage. The prayer of the petitioner may not be allowed at this stage. This court has considered the submission made and has also perused the petition as well as the copy of the case diary produced before this court today. Firstly, as far as the nature of the injuries sustained by the victim is concerned, the medical report dated 20/10/2023 filed by the medical officer Bhadbari CHC would show that the patient / victim was brought to the hospital on complaint of physical assault. The cause of assault was infliction by a sharp weapon. However, at that point of time, the observation as far as the injury is concerned is that it was a simple injury. Next, on perusal of the statement made by the eyewitnesses, what is noticed is that the said eyewitnesses have seen the incident, have witnessed the incident, and have also named some of those persons involved. The person who was holding the sharp weapon or knife and who has allegedly stabbed the victim was not the petitioner herein. However, the petitioner was also named as one of those persons who has helped the victim when the incident occurred. At this point of time, it would not be proper to come to any definite conclusion on this in this regard. Suffice it to say that the investigation would be allowed to take its own course till the IO complete the same and a charge sheet to be filed. As far as the prayer of the petitioner is concerned, considering the fact that he is a young person and is to appear for his examination, this court on this ground is inclined to allow the prayer made. Accordingly, in the event of his arrest, the petitioner is directed to be released on bail. He is, however, directed to fulfill the following conditions: that he shall not abscond, or such I to hadin mo to tingo jo I that he shall not abscond or travel. Petition disposed of, no cost.
Highly obliged.
Should I return the CD to you?
Copy,
This is just a
it's a Xerox copy, Lordship. Xerox copy.
But you have not given the complete. You see, that statement made would have been
Yes, a statement made by the complaint or
important.
By the petition.
petitioner.
Let the investigation
Yes, Lordship.
take its own.
Highly obliged.
Second call from supplementary cause list, item number 3.
Meet, please, Your Lordship. Lordship.
Supplementary cause list, item number 1 for pronouncement of judgment.
You will read out or I will read out? I'll not read out the complete judgment, only some operative portion. This court is in agreement with the findings of the learned single bench as far as the arbitrary conduct of the respondent JCDC is concerned, thus depriving the appellant petitioner her right to be considered for allotment of the contract. However, as to the observation and finding that the tender process in question was abandoned upon the decision of the respondent JCDC to shift the location from Mukundur to Pleittershee, with no materials on record available and more so on the admission of the respondent JCDC that there is no record of the tender process being abandoned, as observed above, it stands to reason that the same is still subsisting. The observation thus made is to be faulted herein. In view thereof, the finding of the learned single bench that the tender process was abandoned upon the decision of the respondent JHADC to shift the location stands interfered with. In the light of the above, this court finds that since the said tender process is not yet concluded, the appellant is to be given a fair opportunity of being considered for running of the said check station at Mukundur, unless decided otherwise by the respondent authorities in accordance with law at the conclusion of the said tender process. To the extent indicated above, this appeal stands disposed of, no course. So the tender process will continue. It's for you to decide. You are the master of the process. If you want to abandon it, it's up to you. You want to continue with the petitioner, it's up to you. Thank you.
Item number 2.
May I please your lordships. My lord, in this writ appeal, as pointed out by learned senior on the last occasions, that few pages were missing in the appeal, which were a part of the writ petitions, my lord. So, my lord, we have identified, and volume 1, part 1, some correction has to be done, and also part 2, my lord, around 5-6 pages needs to be inserted after page 817, my lord. So we have gone to the registry. Registry is saying that since there is no order, we cannot do that. So that is why I was compelled to mention and seek my lord's directions in that aspect, my lord. That is, and the second thing is, my lord.
Yes.
Yes, and the second thing is, my lord. Now during the pendency of the writ appeal, writ petition, of course, my lord. Third party interest has been created, my lord. So in this writ appeal, my lord, the successful bidder has not been impleaded, my lord. If I may permit it, I will make him a pro forma respondent, my lord, so that
for that you do not need permission from the court.
My
you
lord,
have the liberty. If you want to impute somebody, you want
lord.
to strike off somebody, that is
my lord,
I don't think this is required to pass any order.
my lord.
So far as the first part is concerned,
my lord,
about the correction.
yes, my lord.
Yeah, that we can.
My lord. Obliged.
What do you say?
My lord, I had raised two objections, my lord. Some vital documents are not annexed, my lord. And the second part was that the writ petition was 50 pages, my lord. I have a copy of the writ petition. Counter affidavit is 57 pages, my lord. So total 107 pages, my lord. This paper book is of 843 pages, my lord. So total should be 120, maybe memo of appeal another 20 pages, my lord. But this is 843 pages, my lord.
So
what documents they have annexed?
Okay. So you mean to say that they were not, part of the pleadings?
My lord.
My lord, we have compared, my lord, we have compared in the, because the writ petitions, my lord, we have compared with the registry, which is already on the record, my lord. After comparing that, my lord, this, we found that these are the few pages that has been missing, my lord, in the, from the writ appeal, my lord. So if my learned senior says that, my lord, because I have been asking them also, I don't want to say all these things, I have been asking his office, please give me so that we can finish it in fairly. I was not getting cooperation. Anyway,
No, the observation,
Yes.
not say objection,
yes,
but the observation is that there appears to be more paper than are necessarily, required.
my lord.
So what do you say about it?
But my lord, I have the writ petition, my lord. Is 50 pages is the last page, my lord. Counter affidavit 57 pages is the last page, my lord. So 107 pages, my lord. Memo of appeal, lordship will see 800. My lord, they annex any document, whatever they get, my lord. That in my
You
humble
see,
submission is not.
whatever is not relevant, why would you, annex it or rely?
Because my lord,
At the
now,
time of hearing, you can produce any,
My lord,
any
my lord.
document or decision that will, or authority that will support you. But as far as the
my lord, because now there's some time left till from till the time we finally hear this matter. So, my lord, may kindly permit me this, and I will take. I will
we will
again.
do one thing. We will do
Yes.
one thing. We will simply pass an order that on your prayer to do
Correct.
some
Yes.
some necessary correction.
Yes.
We will allow. If
Allow correction,
if
my
that
lord.
part is also required for you
Yes,
to
yes, my
take
lord.
out whatever is not necessary,
Yes.
you can do that.
My lord, my lord, yes. Only that direction, my lord, for allowed to correct this.
Whatever is necessary.
Yes, my lord, necessary.
As
My lord. That deeply obliged, my lord.
My lord, to make so many changes in this memo appeal, my lord, they can withdraw and file afresh also, my lord.
I was thinking about that also.
My lord, the only concern here is, my lord, the memo of appeal, the contents, the grounds will remain the same. Only with regard to the annexures, my lord. So, and those annexures also were, it's not from anywhere, it's a part of the writ petition, 3 writ petitions which has already been filed.
See, Mr. Yugan, I think what Dr. Musika said is, is correct in the sense that it would be better for you.
My
Just
lord.
look at this. This is a bulk.
Yes, my lord.
Volume 1 and Volume 2.
My lord.
You take the whole thing out, withdraw the matter, file a fresh one, and then, that will contain only those papers which are necessary.
Which are necessary for
and
the,
that would be,
my lord.
that would also be helpful for the judges
Yes, my
to,
lord.
to look
My
into.
lord.
Plus, they have to implead a party if they want to, my lord. They can withdraw and file afresh.
Yes, if you want to implead the,
Yes,
the additional party,
the third party, my lord.
that is what you can do.
My lord, for now, my lord, may kindly give that corrections. I'll take instructions, my lord, because my clients are from Delhi, so I'll just take instructions, and then, my lord, appropriately will I will.
Mr. POV, counsel for the appellant has submitted that the papers submitted before this court, the memo of appeal, in the memo of appeal submitted before this court, there appears to be, there has occurred certain errors which requires correction. It is therefore prayed that this court may be pleased to allow such corrections to be made. Such corrections to be made. We will not record the other.
My lord, yes.
On permit, the same is allowed. The appellant is to make the necessary correction. At the earliest. This is matter after 1 week or 2 weeks.
1 week, my lord.
But the matter was otherwise fixed on 22nd. It will come on same
By
day.
then it'll become infractions, my lord.
22nd?
By then, because yes.
Date is already, it is come by mention memo.
Oh, wait a
Now,
minute.
this came by mention, my lord, but my lord may kindly give me a date, because
So,
otherwise 22nd become infractions, my lord.
Once the matter is listed 22nd, let it be.
My lord, my lord.
Because now
Anything.
since you have come only by mention memo,
Yes, my
only for the specific order for
Yes,
the
my lord.
correction.
In the meantime, my lord, if I get, I may be given the liberty to mention. In the meantime, I get instructions, my lord, to either withdraw
that
or
you
to
can
any,
do.
my lord.
That you can do.
Oblige,
List this matter on 22nd.
my lord. Oblige.
From daily cost list, item number 1.
Yes, please start.
Alright, this is a review petition, my lord, and for recalling the order dated 26/2022 passed in WPC 309 of 2022. My lord, may kindly come to the